Hello everyone, my name is Ehi Ua. I'm an attorney here with the Ua Law Group, and I wanted to go over a recent case that was just decided on today, which is July 15th. It's a Ninth Circuit case. It's coming out of California, and it's dealing with, rehabilitation of a convicted drug user, and these are minor drug offenses. So the Ninth Circuit today decided that, rehabilitation is no longer going to eliminate that first conviction for the purpose of, immigration considerations. Right now, before this case, if you were convicted of a minor drug offense and, the court granted some sort of expungement if you, showed over the course of probation that, this was a one-time thing and you're a new person. That normally will be expunged from your record, which means it'll be removed from your record for, other purposes such as immigration. This new case is saying that this will stay on your record. And it's important because with immigration, one thing that immigration does not, tolerate is drug offenses. So if you have something with a marijuana charge or distribution of any sort of controlled substance, most likely you will be denied any sort of citizenship, permanent residency, or continuation of a visa. So this case is very important. It's something that a lot of people should think about if they're here on a visa, if they do engage in, activities, recreational drug activities. If you get caught, this could come back to haunt you. The one good thing about this, it's good news, is that it's going to be a prospective decision, which means anyone who, agreed to a stipulation that, if they went through a probationary period and, rehabilitated themselves from this drug offense, anyone before July 15th will still be able to use, I believe the case name is the Lujan Armendariz. I'm not sure if I pronounced that correctly, but that's the case that stated that, rehabilitation can be granted and, the drug offense will not be put on your record. But anyone before July 15th will still be under that rule. Anyone convicted after July 15th, you won't have that protection. So anyone convicted after July 15th, you won't have the protection of knowing that, an expunged criminal drug offense will not be considered for immigration purposes. Anyone before July 15th, you will still have this, this protective barrier, this protective case, pretty much. So it's something to think about. If there are any more questions about this, you can always contact the Ua Law Group. Come to our website, it's www.ualaw.com, or you could, give us a call at our offices. I'll post that number right after this. But if you need more on this case, you can always search it, Google it. Lujan, I'll put the post up because, I might say the name, you still might not know how to spell it. So I'll post up the case and I'll let you guys know exactly where you can find it and where you can read up on it. But contact us if you have any more questions, and thanks for listening.